Hello and good afternoon to all who are joining from India and a very good morning to all joining from Germany. I am Monaz Desai Tanshe from the Indo-German Chamber of Commerce, and together with our very esteemed knowledge partners, Rödl Partner, I would like to welcome you all to our webinar on and very aptly titled Work Hard, Compliance Harder. How to digitalize and ease your labor law compliance management under the recent and upcoming law amendments. Rödl Partner's success story starts from Nuremberg in Germany from 1977 and continues in the Indian subcontinent since 1997. Today, Rödl Partner advises more than 350 German companies. These services are provided by over 150 enterprising employees and committed partners. So in a nutshell, ladies and gentlemen, they are a one-stop shop for all your legal, tax declarations, BPO, and audit services. Moving on to our speakers for today. Ladies and gentlemen, they have accumulated vast experiences and know-how in their respective fields. Our first speaker, Apurva Singh, consultant, Pune. Apurva has completed her BSL LLB from Pune University in 2018 and since then has been working with Rödl Partner India. Her core area of expertise include employment, labor law related matters, property and commercial law aspects. Our second speaker, Ms. Ursula Hoffmann, Senior Consultant, Mumbai. Ursula is a German qualified lawyer and has been working since 2 years as senior consultant with Rödl Partner. She specializes in the field of market entry, labor laws, cross-border employment, and oversees the renewable energy sector for Rödl Partner. I welcome you both, dear speakers. Today, addressing us also is Mr. Rahul Oza, Partner and Head of Advisory, West and South India. I request our audience to put clear questions in our chat box on the right-hand side. We will take the questions at the end of the session. In case we are unable to take them live, someone from the Rödl team will definitely get back to you offline. Also, you will find a Rödl Partner handout, so please do download it. I wish you all a great session, and Rahul, the floor is all yours. Thank you.
Thank you very much, Monaz. Thank you very much for your kind introduction. That puts now the benchmark of our presentation very high, which is actually not my issue, it is my team members' issues, and I'm pretty sure that they will be managing it perfectly. I have my two colleagues who are very knowledgeable and very experienced in this field. I just wanted to thank you for all the attendance and people who have shown interest for this very important topic. The first list of attendees was very vast and very long, and it is clear why. Because we are facing a very good and very important paradigm shift, which has been discussed in India since many years. Wherever foreign investors do invest in a country, they always expect easy labor law. Now, do we have now easy labor law? I think Ursula and Apurva will give you a light on it, and it will be not really much easier. We don't need actually an easy labor law. We don't want to replicate US, where people are where our employees are scared and uncertain in their existence as a in the company. We need labor laws which are clear in their structure, which are helping to get rid of non-performing team members, who gives a clarity in case of a litigation. It can't happen that a labor law dispute goes on for years and years. The employee as well as the company need certain clarity, clear guidance, and effective decisions. Let us have a look what this amendment has brought to us. I'm pretty sure it is not the last and best reform, but it is a good step into the right direction because it gives a certain unification, a certain comprehension, which helps foreign investors, especially in our case, German investors, to take easier decisions on the Indian market. I would like now to hand over to my colleagues. I'm happy to have you all here. Please do contact us if you have any further questions. We are always there. Our contact details are in our presentation, which the IGCC will circulate afterwards. And enjoy the session with our two best labor law colleagues, which we have. Thank you very much. Apurva, Ursula, will you take over?
Yes, thank you, Rahul.
Yes, thank you.
Just for clarity purpose, I meant you two as my two best labor law experts. If there was any confusion on this point.
No. Can we start with our presentation? Yes, the next slide, please. Good afternoon, everyone. First of all, thank you for taking out time from a busy schedule to join us at this webinar. So, the 4 labor codes, the Code of Wages 2019, the Social Security Code, and the Occupational Safety, Health and Working Conditions, and Industrial Relations Code, as Rahul has rightly mentioned, are aligned with the Indian government's labor reforms, wherein the 29 current central labor laws relating to the wages, social security, occupational safety, and industrial disputes have been subsumed into 4 labor codes, aiming to establish transparent, answerable, and simple mechanism, and from ease of compliance perspective. And they have reduced the registration requirement to just 1 from 8, and need of license has also been hoping to reduce from 1 from 3 to 4, which are currently existing under the labor laws. Last and not the least, these reforms have been introduced to ensure ease of doing business in India, to attract the foreign direct investment and also domestic investment, creating the environment for development of business and industry in the country without compromising with the basic aspects of safety, security, and health of workers. Before we take you through the key provisions of these labor codes, other labor laws which have at the moment have been left out from this ambit, they will continue to remain in force. For example, your POSH Act. Now, the main question is with regard to the enforcement dates of these newly introduced laws. The date of entry into force of these labor codes is yet to be notified. After the passage of legislation in Parliament, it has been sent for the President for assent, and now there are rules which will be then framed by the Labour Ministry for implementing the laws and will be circulated amongst the stakeholders for further comments. The draft rules for Code of Wage Code and the Industrial Relations Code have already been released by the government last month to receive feedback. Once the rules under these labor codes have been notified, these labor codes will be then brought into force. We are expecting to see these laws to be implemented hopefully by January next year. Also, we are also hoping that the government may also come up with a scheme related to the timelines for various business stakeholders to ensure smooth transitional phase to these labor codes. Can we move to the next slide, please? The wage code. Now, the wage code merges the 4 current existing labor laws. As you can see, the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act into a single piece legislation. A statutory right has been created for the minimum wages and the timely payment of wages to all workers, and it extends entitlement of minimum wages to all workers in the country as against 30% of the workforce at present. Currently, the provisions of the Payment of Wages Act is applicable to workers and employees below a particular wage ceiling, which is at the moment is earning up to 24,000 per month. And the Minimum Wages Act mainly is extended to certain type of employment included in the schedule, covering manufacturing sector, mine sector, building, construction, so on and so forth. This extension now will take place to entire service sector, which includes your IT, hospitality, transportation, even domestic workers and unorganized workers for that matter. In line with the Equal Remuneration Act, which basically prohibited the gender-based discrimination in terms of payment of wages, the wage code also prohibits employer from resorting to discrimination amongst employees on the grounds of gender in respect of the same work or of similar nature done by an employee. Now, the definition which is given under the code with regard to same work or similar basically means in respect of which the skill, effort, experience, and responsibility which are required or when performed under the similar conditions by the employee of any gender is the same. In case there is a dispute on this question of work with regard to same or similar nature, the wage code has also provided for an appropriate authority who shall decide whether it construes as such or no. Can we move to the next slide, please? Now, the most important part is for the first time, all the 4 labor codes have now introduced a single uniform definition of wages. There are almost 12 definitions of wages under the different labor laws, often leading to litigation and difficulty in implementation. For dealing with this issue, the wage code provides a uniform definition of wages. As per section 2Y, the wage code means all remuneration, whether by way of salaries, allowances, or otherwise expressed in terms of money, which have been paid to a person employed in respect of his employment. Here also they have mentioned about, as you can see, the excluded components which shall not constitute to be part of the wage. This basically includes your house rental allowances, your conveyance allowance, and so on and so forth. However, it is pertinent to note that a condition has now been attached in the Code of Wages for the first time, that excluded components that we are looking at, if you see from conveyance from A to I clause, they all cannot exceed 1.5% or such other percentage as notified by the appropriate government with regard to your wage. In other words, that wages cannot be less than 50% of the total remuneration or 50% of the CTC. So eventually, we still have to understand more once the rules have been notified. But in this scenario, of course, HR professionals and industries across would have to see the salary structuring accordingly. Can we please move to the next slide? Now, minimum wages. The wage code prescribes the central government and the state government for fixing the minimum wages. For private sector establishments, the state government shall have the authority to fix the minimum wage. For the first time, the concept of floor wage has been introduced under the wage code, and the power and authority to fix this wage code has been vested with the central government, which shall take into account the minimum living standards of a worker for different geographical areas. The minimum rate of wages shall be reviewed and revised in intervals not exceeding 5 years. The wage code has also given a power to the appropriate government to fix the number of hours of work which shall constitute a normal working day, and will also provide a weekly rest. This is important from the point of perspective of overtime wages, where it says that in case the employee works in excess of normal working day or work on a rest day, they shall be entitled to the overtime wages, which must be at least twice the normal rate of wages. Different time limit for payment of wages have been prescribed. For example, in case of a monthly basis, the wages have to be paid for the expiry of the 7th day of the succeeding month. Another condition that in case of removal, dismissal, retrenchment, and resignation or unemployment due to closure, the wages are required to be paid within 2 working days. With regard to statutory payment of bonus, provisions related to the computation of bonus are consistent with the current law, which is your Payment of Bonus Act. For the purpose of applicability, the status also remains the same, that it shall be the Act at once will apply to establishments having 20 or more employees that have been employed at any of the accounting year. The threshold, however, for the salary for the purpose of coverage is yet to be notified by the appropriate government. The wage code also prescribes the records and returns, which would be briefly covered by my colleague as well. And we will get to know more once the rules also have been released and notified. But so far as it goes, we'll have to maintain wage registers, requirement of issuing wage slips, and so on and so forth. Interesting feature is that everything now it has basically digitalized, which was not earlier included in the old laws, but here the stress has been to maintain all these things in a digitalized format. Can we move to the next slide, please? Now, the wage code and other labor codes also, one of the interesting features is that they have introduced a web-based, randomized, computerized inspection scheme, which will be inspection. They will be calling for information electronically. And all these changes are all set to form a conducive environment for enforcement of labor laws with transparency and accountability. As far as offences goes, the wage code provides that any employer who pays to any employee less than the amount due to such employee under the provisions of the wage code shall be punishable with the fine, which may extend to 50,000 rupees. And if the offence is repeated for the second time, or if the employer is again found guilty within 5 years from the date of either committing the first offence or the subsequent, then the same will be punishable with an imprisonment which may extend to 3 months, or with a fine which may extend to 1 lakh, or with both. There is also a provision of compounding of offences, but all of these we'll get to see more once these rules have been notified. Moving on to the next slide. Now, coming to this Code on Social Security, as you can see, it aims to consolidate 9 labor laws relating to the Social Security. Relevant ones which include the Employee Provident Fund Act, the Employee State Insurance, the Compensation Act, the Maternity Benefit, and the Payment of Gratuity. The code has widened the coverage by including the unorganized sector and fixed-term employees and gig workers and platform workers, including the interstate migrant workers and contract employees. As you can see, the interesting feature is that we get to see the term they have used for the platform worker or gig worker, which was not earlier included in our current existing labor laws. Now, the platform worker is defined to mean an arrangement which is outside the traditional employer-employee relationship, in which the organizations and individuals use an online platform for problem solving or to provide any specific services. So this covers, like, we have the various companies who are indulging into app services through whether food delivery, and also all of them would also be now fall within the ambit of Code of Social Security and will have to comply with the same. Can we move to the next slide, please? Employee state. At present, the ESI Act applies to every establishment wherein at least 10, or in case of Maharashtra, 20 covered employees. That is, employees who are under the threshold of 21,000 per month. There have been conflicts in the past, like with regard to whether it is applicable to 10 workers or 10 10 covered employees. The code basically puts an end to this ambiguity by clearly clarifying that the Employee State Insurance Act will apply only when there are 10 or more covered employees in the factory or the establishment. For the first time also, there is also option for ESIC for establishments to get them registered even in case of less than 10 workers. However, it is pertinent to note that establishments working in hazardous sectors would be mandatorily linked with ESIC even if there is only one worker working in it. For Employees Provident Fund, the threshold for mandatory application with respect to the establishment having 20 or more employees continues. The option for having voluntary coverage has also been retained here in case you're having less than 10 employees. Another interesting change here is they have been given the option to opt out for establishments covered voluntarily under ESIC and Employment Provident Fund. So with this in the code, those who have taken the voluntary coverage, the provision also allows to opt out of such registration. For this, the employer will have to make an application to the, in case of ESIC, to the Director General of State Insurance Corporation. In case of Provident Fund, Central Provident Fund Commissioner for opting out. A new provision of fixed term employment is introduced, which basically allows the engagement of the worker on a fixed term basis, on the basis of requirement and without restricting any sector, and on the basis of written employment contract. However, there are certain conditions also for engaging the fixed term employee. Some of them are that the working hours, the wages, allowances, and other benefits shall not be less than that of a permanent worker doing the same work or of similar nature. Secondly, they shall also be eligible to all the statutory benefits at par with the permanent worker, according to the period of services that they have rendered, even if the period of employment does not extend to the qualifying period of employment required. This takes us to the next thing with regard to the gratuity. As you can see, in case of gratuity also, basically the fixed term employee would also be eligible to receive gratuity even though they have rendered 1 year of service, and the pro rata of term that have been performed by them shall be taken into regard. So the minimum 5-year services which is given normal circumstances, the gratuity would not be applicable here. So this is a major change to be taken into. Moving on to the next slide, please. As you can see, we have to, there are records and registers which have to be maintained here. Offences, stringent penalties have been imposed in case of contravention of any provision. Depending on the offence, it may the fine shall range from 50,000 rupees up to imprisonment of 3 years. Again, as you can see, they have also imposed enhanced punishment in case of repeated offences, and the punishment is pretty high, where minimum imprisonment of 2 years, which may extend to 5 years, and also a fine up to 3 lakh rupees. Compounding of offences is also applicable in these cases, in this provision as well. Move to the next slide, please. Coming to the last one for my session, the Occupational Safety, Health and Working Condition Code. This code replaces the 13 labor laws related to the safety and health and working conditions, and some of which relevant that you can see is the Factories Act, the contract labor, the interstate migrant, all of them are subsumed into this code. For us, it shall be applicable to any place or establishment having 10 or more workers, whether any industry, trade, business, manufacturing or occupation is carried out. It is applicable to the factory, motor transport and mine or port, so and so forth, as you can see here. The code basically aims at lessening the burden of the employees, as it has decided to be done away with the multiple registrations under various enactments to one common registration and one license and one return from the ease of doing business perspective. Establishments which have been covered under the code are required to register within 60 days of the commencement of the code electronically by applying to the registering officers which have been appointed under this code. Next slide, please. Threshold limit of factories has also been expanded to have 20 or more workers with 8 of power and 40 or more workers without the 8 powers. However, the appropriate government has been granted the power to declare any place where the manufacturing process is carried on as factory, irrespective of the numbers of workers employed in such factory. This is relevant, and generally we get to see in the cases where the factories are involved in the hazardous activities, and it becomes pertinent to stick to certain safety welfare measures. Accordingly, this threshold won't be applicable to factories. The duties of employer, it lays down the duties of the employers and employees, and also envisages the safety standards for different sectors, focusing on the health and working conditions of workers, hours of work, leaves. Another interesting point here we get to see is now that there has been a duty to impose regarding issuing of appointment letter to every employee in the establishment. Eligibility to earn annual leave has been reduced from 240 days to 180 days in a given calendar year. Can we please move to the next slide? Duty to intimate and send notices have been imposed, which are also currently existing in the Factories Act as well. And for example, there is a duty to intimate if case there is any change in the ownership or any management change, and within 30 days of such change. In case of closure, also there is a duty to intimate to the concerned appropriate authority. Notices also are required to be given in case of dangerous occurrence on the premises of an establishment in case of factories. So this pretty much has remained the same. For contract labor, with respect to the contract labor, special provisions have been introduced. It shall apply to establishments or contractors employing 50 or more workers on any day in the preceding 12 months. And here the code for the first time have introduced the concept of core activity in the establishment, wherein it basically prohibits employment of contract labor in the core activities. There are exceptions to this case, in which case the contract labor may be engaged by an entity for a core activity subject to fulfillment of certain conditions, some of them which include, first, the normal functioning of the concerned establishment itself being as such that activity in this question is ordinarily done through contractors, or if there is a sudden increase in the volume of core activity which needs to be completed within a stipulated time, then in that case the core activity could be permitted for engaging the contract labor. As you can see, there are also exceptions where they say that the activities which shall not amount to core activity, where you're engaging into the security services or any activity of intermittent nature. With respect to the interstate migrant workers, the applicability shall be to those establishments who are employing 10 or more workers, and they have to provide suitable working conditions to these workers, and also to further extend benefit to state migrant workers in these establishments. The employer shall also be liable to pay to every state migrant worker every year a lump sum amount as journey allowance towards his travel to his native place. Compliances and registers have to be maintained here. Like I've mentioned that the government will be coming up with a scheme to reduce the number of returns to be filed under the respective laws, and also the register would be kind of a unified, so that in order to lessen the burden compliance. It's in the talks that the appropriate government may also come up with a scheme to have a third-party audit and certification in the randomized manner, just to check whether these establishments are complying with the laws, which would be notified later on. A special provision has been introduced where the central government, considering the COVID situation and the pandemic, where the central government is also empowered to make regulations for the general safety and health of the persons in the event of any pandemic or disaster. Finally, it also provides for the National Occupational Safety Board to be constituted. Earlier, earlier in other laws, there were like multiple boards which were constituted. So now there'll be a single authority. For offences and penalties, as it's been listed here, that obstructing, some of them, that obstructing discharge of duties of inspector invites imprisonment up to 3 months and fine up to 1 lakh. And if an offence which leads to the death of an employee will also be punishable with imprisonment, which may extend up to 2 years or fine up to 5 lakh rupees or both. And where no penalty is prescribed with regard to contravention of any of the provisions, the employer will be punished with the fine ranging between 2 to 3 lakh. Also, as I mentioned, that there are certain duties which have been also imposed on the employee also, employees when they're working in the factory premises. So in case of violation of these duties by the employee, there's also a provision which also imposes fine up to 10,000 rupees on these employees. Now my colleague Ursula will take you through the Industrial Relations Code. Thank you so much.
Thank you, Apurva, for handing it over to me, and also from my side, a warm welcome to all participants today. I will start with the Industrial Relation Code 2020. So this code covers the Industrial Dispute Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. And it has significant changes in a few important definitions, some important changes regarding the recognition and negotiating with trade unions. And interestingly, just on Friday, the draft rules under the Industrial Relation Code actually got published. So through these draft rules, we have a first insight on the compliances which will come along with the codes. For now, we just have the rules under the Industrial Relation Code, but we get an idea in which direction it will go. So yes, next slide, please. Before I start with the changes in the regulations, I would like to highlight a few important definitions, and especially the changes in those definitions. To start with, the definition of employer also includes now the occupier of the factory and the manager of the factory. And in relation to any other establishment, and includes the person who has the ultimate control over the affairs, and or the manager or managing director. So this is very important that it is clarified in the code that also manager and occupier and managing director shall be considered as employer. Why is it so important? It is important because it's reflecting in the liability. Because all these labor laws actually are imposing a liability to the employer, and in this mean also to the managing director or manager or occupier. So it means that they can be personally liable under different circumstances under the code. So it's very important to know that because obviously for the employee, for the managing director, and for the board of directors to know, okay, who will be liable under the code. And what we always see in our practice is that there are several kinds of managers which are appointed in a big establishment. But in the end, manager of the factory is probably not defined, and no one has this designation. So we usually recommend that also you clarify that with that person who shall have the responsibility to carry out the labor law compliance, that he will have the set designation, and it's clarified that he will have the responsibility to carry out the obligations under the labor laws. And in case he's not doing that, there might be a chance to be liable. Also, the definition of employer includes contractors, as earlier mentioned by my colleague Apurva. This is basically in all of the codes that the contractor shall be also considered as employer. On the other hand, the definition of worker, here we have a little bit of an extension of the definition, and includes also now working journalists and sales promotion employees. Further, we still have the exclusion of managing and administrative employees and supervisory employees. However, regarding the supervisory employees, the threshold for the salary was a little bit increased up to 18,000 rupees per month. Next slide. So regarding the definition of industrial dispute, here also the definition got a little bit expanded and includes also now in any dispute or difference of an individual worker with their employer, but it has to be connected because of discharge, dismissal, retrenchment, or termination of such worker. And for the definition of the trade union, so if you compare the definition of the trade union in the Industrial Relations Code with the definition which was given earlier in the Trade Unions Act, it's still the same. However, under the Industrial Dispute Act, only registered trade unions were trade unions under the Act. And this is not the case anymore. And that is very important because this means that also non-registered trade unions have the rights and obligations under the industrial dispute part of the Industrial Relations Code, which was not there before. Next slide, please. So now I'm giving you a little bit an overview of the amendments relating to the trade unions. The first point we had already regarding the definition that also non-registered trade unions are treated as unions with the rights and obligations under the Industrial Relations Code. What is new is also that in case an establishment has more than one trade union, then the trade union which has 51% or more workers as the members will be recognized as a negotiating union. In case none of the trade unions is fulfilling this criteria, then a negotiating council has to be established. So this is a completely new concept which was not there before. Something like a negotiating council was not there. And this negotiating council shall consist of the representatives of such registered trade unions which have the support of not less than 20% of the total workers. So this is a very practical step that the government has taken here actually, because a lot of establishments are struggling which trade union should I actually recognize as negotiating trade unions. So that was much more clarified now. However, even though there is a clause regarding the recognition of trade unions at the central and state level, this is not very specific, because this clause actually just says that the central government or the state government may recognize a trade union as a negotiating trade union. However, which criteria the trade union has to fulfill, or if that also puts an obligation for the employer to do so the same, is not actually clarified. So this means that we are back to the old regulation regarding this, which was that the state governments are allowed to issue their own rules and regulations how to recognize a trade union as negotiating trade union. However, so far not a lot of states actually took the opportunity to do so. For example, we have it in Maharashtra, but in a lot of other states it's still yet to be ruled by the state governments, and so there's still some lack of regulation for the employers, for the company, onto deciding how to recognize a trade union as a negotiating trade union. Next slide, please. We have a few amendments relating to industrial dispute. We have in the Industrial Relations Code also a works committee, which was there earlier, also in the Industrial Dispute Act. However, establishments employing 100 or more workers shall constitute the same. Also here, the draft rules actually give a little bit more clarity on how to constitute a works committee. It was clarified that the members of that committee shall not exceed 20, and that there shall be equally representatives of workers as well as of the employers' representatives. Also, we have a grievance redressal committee, which was also earlier in the Industrial Dispute Act. However, now it shall be applicable to establishments employing 20 or more workers. And such committee shall consist of equal number of members representing employer and worker. A new aspect which they have brought up in the Industrial Relation Code is that the committee shall have an adequate representation of women workers, which means that it shall be in proportion of the women workers to the total workers employed in the industrial establishment. To give you an easy example, you have 100 workers, from which 50 are female workers. That would mean that the half of the members which are representing the workers should be female workers. So it has to be in proportion. We have a small change in the definition of the strike. Now also mass casual leaves taking mass casual leaves is recognized as a form of a strike. Further, now trade unions have to give a notice of at least 14 days before the strike. That was only applicable for certain establishments earlier, mostly government-related establishments. Now it's applicable for every establishment. And then we have small changes for the layoff, retrenchment, and closure, which means that the industrial establishment employing 300 or more workers only have to obtain the prior permission for layoff, retrenchment, and closure. So that is quite interesting, because the first draft of the Industrial Relation Code, which was published in 2019, was actually saying 100 in an establishment with having 100 employees or 100 workers shall get the prior permission. So that was changed to 300 workers in order to give the employers a little bit more flexibility on this side. What is also new is that we have a voluntary arbitration, which has to be agreed upon in the employment agreement or appointment letter, however you want to call it. As per the draft rules, it was clarified that it has to be in a certain form, a so-called arbitration agreement, in the form of Form 3 of the draft rules. Next slide, please. We have small changes for the standing orders, which shall be now applicable for industrial establishments with 300 or more workers. Under the Industrial Relation Codes, we also have several regulations for offences and penalties. The penalties start from 50,000 rupees, but can go up to imprisonment of 6 months, depending on the offence. Which is interesting now, which we could see in the draft rules, is that in case of a notice, this shall be actually issued through the Samadan portal. So this means that it is definitely clarified that the government wants to take with these codes a big step towards digitalization, which is very important, especially during times of COVID, that not for every small check on a register, the Labour Commissioner has to come to the establishment, and actually everything will be handled online. So this is clarified in the rules so far, and this is what I meant with we're getting an idea where the direction of the codes and of the compliances will go to. It will go definitely into towards the direction of digitalization of labour law compliance. Further, we have now a defined Schedule 2 for unfair labour practices. Next slide, please. Yeah, let me just quickly say a few sentences regarding the fixed-term employment. Apurva already mentioned a little bit about that. So fixed-term employment just means that it's an agreement on a fixed period, but it's a newly introduced idea, because what the government tries to do is to give the employer flexibility in order to say, okay, you can hire on a fixed term, but in order to protect the workers and the employees, you have to grant them the same benefits as a permanent worker. And in order to do that, they have also reduced the applicability timeline for gratuity from 5 years to 1 year for fixed term employment. However, the code so far does not include a lot of regulations for fixed-term employment, which means that there are no restrictions of the length of the period which a worker may be engaged, or even a cap on the number of times the worker may be engaged as a fixed-term employee. So here it's very important to see where the direction will go if the state governments will introduce more regulations towards that, or if there will be some changes in the draft rules, because right now, since there are just a little bit of rules regarding this and clauses, there might be a possibility for companies to misuse this idea of having fixed-term employment. But obviously, the idea of the government was to basically make a shift from a lot of contract workers or hiring on a consultant freelancer level to at least giving them a proper employment with all the benefits, and if it has to be in a fixed term employment, then it has to be in a fixed term employment. So that was the idea of the government, but I feel there is still some lacking of regulations to actually protect the employees as they intended to. Next slide, please. Yes, to draw a conclusion on these 4 labor codes is, as Rahul mentioned in the beginning, it's definitely a first step in the right direction. It is uniforming a lot of labor laws, and is therefore it's unifying and digitalizing the compliance. And this actually is reflecting in the overall policy of India, of the government of India, towards digital India. So we saw similar steps for GST and other compliances, and so it is really required that they do the same now for labor laws as well. Also, we see that there's definitely a little bit more flexibility for industrial establishments. So a lot of thresholds were increased to provide a bit more flexibility. However, we still don't know exactly how the compliances will be under the codes, because the rules still have to be developed and still have to be notified. Further changes are possible under the state governments. So this we also have to see if there will be any changes. Also, I feel in a few aspects, the government actually missed the chance to give a bit more clarity on certain points. For example, on the recognition of trade unions. So in introducing a new code, they had the chance to remove basically the previous rules and remove the lack of regulation and put there a proper regulation, but still they haven't. So we still have a few spots left where we have no clarity from the government on how to handle things. Also, one thing that Puva also mentioned, but I definitely want to highlight it once more because it's just very important, is that these 4 codes will not substitute all the labor laws. So you will still have other labor laws which will remain effective and which also will still have a separate compliance under the same. So for example, for anti-sexual harassment under the POSH Act, you will still have to file in an annual return, and you still have to constitute an internal complaint committee. So these codes are covering already a lot, but certainly not everything, and it's just something that you need to know and that you have to keep in mind while looking at them. Next slide. Yes, so let me give a quick overview on labor law compliances overall. I will have to rush a little bit through these slides because we are running a little bit out of time. So next slide, please. So this is just to give you an idea of what kind of compliance categories actually exist under the labor laws. And you have returns, intimations, registers, payments, display notices, audits and examinations, and of course inspections and approval. And the interesting part is that a lot of acts and labor laws are actually asking for all of these compliance categories. So my favorite example is the Factories Act as it is now. There you have returns, you have display notices, registers, everything. Actually, all of these categories are have to be carried out under the Factories Act. So this is just a lot, and this just means that even if you have one law, it means that you have several compliance categories where you have to look at and which you have to be compliant with. Next slide. Yes, as mentioned earlier, India just has tremendous amount of different labor laws governing various aspects of the terms and conditions of the employment. And also these labor laws, regulations, they differ from state to state, they differ from sector to sector, and they're also heavily dependent on the size of your establishment. So the first step when you think about labor law compliance would be obviously to see, first of all, which labor laws and which acts are actually applicable to my specific establishment. You cannot read articles in the internet because this is so individualized, they cannot give you an answer for that. So this is the very first step that you have to take care of, to really go through this and have to decide, okay, what is applicable to me? And this is something where perhaps also HR manager may occasionally find it a little bit overwhelming because they probably don't have that specific legal background to say, okay, is this small act or law of labor law now applicable to my operations, yes or not? And this is something where you just need some help from someone outside who's doing that every day. So, for example, Rödl Partner, in order to determine, okay, which laws are applicable to me. And then the second step, obviously, to say, okay, and what does it mean for my compliance part? Which compliances do I have to carry out now based on my previous decision? And based on that, you can create a compliance tracker, which is very individualized for yourself. But just going through articles will not help you because it's just such a specific topic, and which is heavily dependent on how, what kind of establishment you have, the size, etc., etc. And obviously, a very important point is, which I mentioned also earlier, if you're non-compliant, it means that your directors may be personally liable. So it is just very important that you have these HR labor law compliances on your mind, and that it's taken also up serious. So we see that companies are happily taking care of their tax compliances, but sometimes not so much about their labor law compliances, which is actually quite crucial, because under the labor law compliances, even a director which sits in Germany can be personally liable if something goes wrong in the establishment. So this is very, very important. Next slide, please. Yeah, a few more sentences on how we see the future of the labor law compliances and what the government of India is actually doing. So we, as I mentioned earlier, we definitely see the future going towards digitalization of labor law compliances, and actually the government of India has already taken the first step to do so. They introduced this unique labor law identification number under the Shram Suvidha portal, which allows companies to file an annual return for several labor laws, applicable labor laws at the same time. So this is a huge step for companies, which they can do, and which also eases the compliance for themselves. And but unfortunately, we also see that companies are not using this portal yet as much as they could. And a lot is also dependent because a lot of companies are still having a lot just on physical registers, physical agreements. They don't save soft copies on the server, etc., etc. So the first step in order to utilize these portals from the government of India would be actually to do the step in your own establishment towards digitalization. And then the government of India will definitely help you with these tools to ease your compliance. Next step, slide. Yes, how can we help you as Rödl Partner? We offer several services under labor laws, obviously also other laws and tax related, etc. But now for this presentation, we basically help with everything when it comes to litigation, drafting of agreements, termination, notices, negotiating with trade unions. So the full-fledged here. But we are also taking care of your compliance, your labor law compliance. You actually can completely outsource your labor law compliance to us, which is a big thing for you, which would really help your company and your establishment, because also this would minimize your liability risk of the directors and managements and occupiers. So if you're interested in that, we can definitely help you out. And also, which might be important to you, is that we understand also the group level compliances which may be applicable to you, not because a law in India is saying it, for example, data privacy of employee, but because it's a standard of your group companies, which therefore you have to implement accordingly in your subsidiary in India. Yes, next slide, please. Yeah, this is just a quick example for you on the different compliances which have to be carried out on the Factories Act. As mentioned earlier, all compliance categories are actually applicable to you. Since we're running out of time, I would say you can go through this also after the presentation once, just for your own knowledge. And next slide, please. Yeah, and I had mentioned it earlier, but still it's such an important topic for us. It's just that you take care of the compliance risk of your managers and directors. And because you have the special liabilities under certain labor laws, which will also continue under the new labor code. And therefore, it's just very important to implement a compliance risk matrix, compliance risk management, and obviously, if required, in D&O insurance. Okay, that was, I think, the last slide. So thank you from my side. And I would say we start right away with the Q&A session. Monas, to you.
Yeah, thank you, Ursula. And some good news and some not so good news would be that people have posted questions and then they have posted remarks saying that, oh, thank you, we have already, our question has already been answered. But we still have a few. I'll start out without wasting any time. The first one, does the OSH code also apply to IT companies, R&D centers, though they are currently covered under the Shop and Establishment Act? Could you quickly comment on this one?
Yeah, Apurva, do you want to take it ahead?
Yes, fine. Yeah. Yeah, so I already mentioned in my slide before that the OSH code is basically applicable to all the establishments. So there is a difference. The OSH, the Occupational Safety Code basically covers your central laws. So that does not preclude you from your application of the state establishment law. So the answer would be yes, it will also be applicable to IT sectors and other establishments.
Okay, thank you so much. The second one, you mentioned in your earlier slide that gratuity is applicable for workers even if they have worked for 1 year. Is that not a contradiction to the existing law that mandates 5 years of applicability of gratuity? If you even don't want to take the question, you can let me know. But if you like to comment, you can comment as well.
So what we meant to say was that gratuity here, the 1 year contract that we are talking about comes from the employment of fixed term basis, the fixed term employee. For them, even if they have served for a year, it's the gratuity, for the purpose of gratuity calculation, the period that they have served would be taken into account. So I hope that answers the question.
So this is solely for fixed-term employees, as Apurva rightly mentioned, and this is the idea of giving the fixed-term employees the same benefits like the permanent workers. And in order to do so, they said, okay, we have to reduce the applicability of gratuity accordingly. But it's only applicable for fixed-term employees.
And this comes from the point so that the employer, because then employers might resort to engaging into fixed-term employee from the perspective of denying other statutory benefits. So in order to protect their, in order to protect the interest of fixed-term employee, this has been introduced. So it's applicable for them.
Thank you. Okay, thank you so much for clarifying. And maybe we have time for one more. Is it necessary to put up notifications in office premises or putting it up on HRMS or internet serve the purpose?
Like on this, it is necessary, but we see like we come across that it's not complied with. But when they say any law which says that you have to display the statutory notices and everything, so yes, you're supposed to do that. It is compulsory.
All right.
But in case you have, for example, sorry, just one, in case you have a policy, that would be fine to save it on the server and would actually make it applicable to the employees while giving the option of basically having access to that service. So that would be possible. But when it comes to notices and which are verified in the act, then you have to actually hang them physically in your office.
Thank you so much. And when are we expecting these implementations?
So like I already mentioned at the start of the presentation that we got to see only the draft rules which have been released for code of wages and industrial rules. We are still waiting for the draft rules to be released for the other remaining 2 labor codes. And we, I mean, it's in the news that government is trying to, you know, put it all and like by the end of December, January, but we still will have to see. But we are hopeful that it will be implemented soon. But rest assured, there will be some, I'm sure the government might come up with some scheme in order for the establishments and the industry to smoothly transition into the phase. And we will get to see more clearly once the draft rule, once the notified rules come into picture.
Thank you, Apurva. And really, finally, the last one. For confirmed employee or employees on roles of the company, is there any change for gratuity tenure for the ones who are already confirmed?
No.
All right. So I think with that, there are some more questions coming in, but as I said earlier, that we can always, somebody from your team can always take them offline. I now invite my colleague, Ms. Rödl to give the vote of thanks.
Thank you, Monaz. Well, on behalf of the Indo-German Chamber of Commerce, we would like to thank our knowledge collaborator for this webinar, Rödl Partner, and our speakers and panelists, Mr. Rahul Oza, Ms. Apurva Singh, and Ms. Ursula Hoffman, for this very comprehensive and relevant session. And we thank you all, dear attendees, for your participation and patient listening. Please do write to us, sharing your valuable feedback. Just a gentle reminder to please download the company's service brochure from the handout icon to the right of your screens. Also, this webinar will be made accessible for your viewing and information on our website shortly. Last but certainly not least, an appreciative note of thanks to my colleagues of the events team, namely Meera, Sana, Monaz, and Hani, for successfully putting this webinar together. Thanks also to Nikhil and Samia for their support. Please visit our website to know more about our upcoming webinars, and we hope to have your presence and participation at our next event as well. Thank you, and until next time, keep well and stay safe. Thank you. Bye-bye.
Thank you, Rödl. Thank you, ladies. Thank you, audience.
Thank you so much.
Thank you.
So much.